David Rogers Webb is the author of a book called The Great Taking, and I saw the video on it here a few months back, and I was absolutely amazed. This is such grand information. We need to listen to this like you've never listened to anything before. David Roger Webb cut his teeth in the financial industry in New York, on Wall Street. He was involved in some of the most amazing things that happened in the late 90s and early 2000s, and has such an amazing background. You can't believe this gentleman's background is so good, and he knows so much about money, and he knows so much about finance. You cannot miss from anything you get out of this. So with that said, I want to introduce our afternoon speaker, David Rogers Webb.
Dan, thank you. Thank you. Thanks so much. You know, firstly, Of course, I want to say I'm very grateful to Ed for this opportunity to be here, but I also want to take the opportunity, if I may, to speak for many people, to express our gratitude to Ed for the many, many years of work on our behalf, which he continues to do, quite obviously. And also, our gratitude to Pat, who has been his lifelong companion through all of this, and to their magnificent son, Dan, who is looking after them. There he is. And, you know, along with that, I think goes a lot of love and respect for the Griffin family. And I'd like to say my own father would have loved to have met you, Ed, and would have loved to be here so much now. And I think, he is, really. So, the truth is like a lion, you don't have to defend it. Let it loose, it will defend itself. And this is a quote I borrowed from a fellow named Eddie Hobbs, who is doing just this in Ireland right now. So let's get into it. For 400 years, securities were property. So we had certificates, and the beauty of that was that you were bulletproof. This was your property. There was an absolute bright line as to who controlled that security, that collateral. What has been done is to shift that certainty of collateral from the public somewhere else. And I assure you that has happened, unfortunately. So what we have now is what they call an indirect holding system. We have beneficial ownership, which is just an appearance of ownership. In other words, you can decide to buy something, you can decide to sell it and get the gain or the loss on it. You're paid the dividends, you receive a proxy statement. So it appears that you own it, but all the while, the legal control of the security is elsewhere all the time. The one thing that is certain is that you do not have legal control of the security. So it's an appearance of a property right. They call it a property right. It's basically a lie. And we'll get into why that is the case. So it does not function as a property right in the case of insolvency, which is when that matters. So this is directly connected with the phenomena we're in, the derivatives bubble, the growth of the entire derivatives complex. That was made possible by subverting property rights to securities globally so that they can be used as collateral elsewhere in the financial system. So this was done deliberately. It was relentlessly implemented over decades, and it was done definitely deceptively. So this is not accidental. This is not something that just happened organically. So dematerialization was the first step. What that means, book entry record keeping, electronic record keeping, so no longer having physical stock certificates, which actually work quite well. Now, dematerialization, when you look at this, and I'm not going to spend a lot of time on it, but it's very clear that this was a CIA project. The man that was appointed the head of Depository Trust Corp., which is the depository for all securities in the U.S. and much of the world, was a career CIA operative. And this is the key thing, he had no background in any aspect of banking and finance. And this is discussed in his own memoirs and in interviews he's done. Then this regime was pushed globally by the U.S. State Department. So this has been done from within the U.S. system over half a century, a bit more than half a century. So these are the key facts. You had ownership, but now that property right, which actually worked quite well, when it was a certificate, you could deliver it to your broker, but you had to explicitly do that and sign it over so that it could be used as collateral elsewhere. But if they were holding your securities if you had not signed it over, you absolutely had the right of return of those securities because it was your property. Now you have a new concept, newly created with this amendment to the UCC in '94, of a security entitlement. And that works more like a contractual claim in the event of a bankruptcy. And you may know a contractual claim really is very weak. If a company goes bust, it's essentially you're out of luck. Now, all securities are held in pooled form. And this is the key thing. If you have asked your broker not to extend your securities as collateral, they may assure you that they are segregated. That's only in the books and records of the broker. This is the subterfuge. At the higher level in the system, all of them are in the same pool, and they are used without restriction. So they can tell one party, oh, we're not lending your securities out. Meanwhile, they're all being used. So all account holders, including those that have said, I do not want you to loan my securities out, and all of them receive only a pro rata share of what is left in the pool after the secured creditors take the securities out of the pool. So there is no way in this system to have absolute assurance of return of your property if the intermediary becomes insolvent. So the revindication means that you could take your own security back if the broker failed, which would have been the case for 400 years when it was your property. If your broker failed, it was their problem. It wasn't your problem. Worked quite well. So within the system, the account providers can use the securities out of these pools. They basically extend them under swap arrangements or stock loans, and they can use those securities without restriction, no limit whatsoever, and free of payment. This is how it works. And then I'll get into this. There were changes made to something that called safe harbor, which assures that the secured creditors have priority ahead of account holders in an insolvency, even if fraud was involved, even if the securities were used wrongfully, the secured creditors prevail. Whose idea was that? And this has been upheld by the courts. So how can we know all this? This is very important. when the Europeans were being pressured to conform to this, and you can see this going back to 2004, it was beginning after the dot-com bust, they set up something called the Legal Certainty Group. Now, what's meant by that? They mean making it legally certain that the secured creditors get the assets. It sounds like it's a good thing, but that's what it is. So they sent a questionnaire to the New York Fed. Now, the New York Fed is really the Fed. You know, that is the business end of the Fed. And in March of 2006, the Deputy General Counsel responded to this detailed questionnaire from the Legal Certainty Group. And I want to just take a moment and say the man that found that document is sitting right there. This is Lars Johansson, who has been working with me for over 10 years on this stuff, and he found that document in maybe 2011, something like that. Now, this document is a real gift to us because it shows irrefutably. This is from the highest source possible. These are attorneys working for the New York Fed itself. So this isn't like reading an article about it. This isn't conjecture. This is a formal legal response from the Fed to the EU. Now, first question, what legal system are you referring to here? And it is specifically about Article 8 and 9. Which you'll hear about. This is the area that we're addressing in the UCC to make changes to restore property rights. So this is specifically about that area. And this, at that time, this is 2006, it had been adopted in all 50 states. So where the securities are held in pooled form, does an investor have rights attaching to particular securities? No. Just very simply, no. You have a pro rata share, and this is key. This is true even if investor positions are segregated. Now, institutional investors, sophisticated people, want to believe that their funds are segregated. They are diluted. It is absolutely not the case. So we're not just talking about individual investors here. This is pension funds. All investment funds are subject to this as well. Everything. There's no way out of this. Is the investor protected against insolvency of the intermediary? An investor is always vulnerable. That's the situation they have created. The investor is always vulnerable to a securities intermediary that does not have sufficient entitlements. Now, as it says, entitlements that it has created. Now, what is happening there? Why do they end up with more entitlements than the securities the investors had? It's because they borrow money, essentially, in the derivatives market using the securities of the clients. So they create additional security interests in those pooled securities. That's why there are more entitlements than just the entitlements of the investors. But it's the secured creditors that have been given the securities as collateral that have priority. So this system assures that in the game of musical chairs, the investors are last in line to get their own securities back. It's absolutely clear. Now, as it says here, if the secured creditor has control, it will have priority. And what has been done here is to create a situation where it is not possible for the investor to have control. It is always possible for the secured creditor to have control, 100% of the time. Now, this is another key thing we'll get into. If the intermediary is a clearing corporation, so DTCC, Depository Trust, where all of these are, and all of the clearing entities for derivatives, Those are clearing corporations. But also Goldman Sachs is a clearing corporation. Lehman Brothers was a clearing corporation. So their creditors always have priority over the clients. This is the Fed itself saying this. What rules protect a transferee? Now, a transferee is the secured creditor that received the assets, which were client assets. What protects the transferee? And Article 8 protects a purchaser. Now, they switched the term purchaser because they're talking about, say, under a swap contract. The way money is borrowed with a swap contract is that treasuries, for example, are bought by, let's say, J.P. Morgan from the fund, and that money then is available as short-term financing. So J.P. Morgan is buying those securities and extending cash, perhaps for a short-term loan. And this is what happened in the case of Lehman Brothers. So the purchaser, Article 8 protects the purchaser. So the lender that has taken the securities as collateral. Article 8 protects the purchaser against claims of the entitlement holder to a property interest in their own property by limiting the entitlement holder's ability to enforce that claim. And then, now that's pretty egregious itself, but then unless the purchaser, so the lender, was involved in wrongdoing, the entitlement holder will be precluded from making a claim. But we'll see, even that is not true because, well, that's one slide after this. Shortfalls. If there aren't enough securities to go around from the pool, the only rule is the entitlement holders share pro rata in what's left in this game of musical chairs. Now, this is very significant. Does the treatment differ if there was fraud, breach of duty? And the answer is, regardless of fault, fraud, or negligence of the intermediary, the entitlement holder only has a pro rata claim. So they've made it absolutely bulletproof for them, for the secured creditors, think J.P. Morgan, that even if there was fraud involved, even if there was wrongdoing, they keep the client assets. So this article in the UCLA Law Review, this was in '96. So the amendments that did this was in '94. They weren't adopted in all states until maybe 2001. So this article is fairly contemporaneous with those amendments being forced on the states. This guy, Stephen Rogers, was the drafter, which means he wrote them. This is the guy who wrote the amendments. So he's at the center of this. And he says, at the time, concerns have been expressed about what we're doing here, about protection of interests of the individual investors. They knew full well there were concerns about this. And that these securities, if they were transferred to a securities intermediary wrongfully, there were concerns about that it was done wrongfully. He said this was given very careful consideration, and a very large number of thoughtful lawyers. So they had to keep going through lawyers, one after the next, started from the standpoint of unease about this, and after careful consideration, found their initial impressions were incorrect. So the lawyers just got more and more expensive until they got a group of them that said, we're good to go. So then he makes a very interesting statement that what this was really about, the Uniform Law Commission wants to make you think that this was all normal. He says at the time, this was about Armageddon planning. This was about preparing for a collapse in the financial system and he says, thankfully, both government bodies and private sector groups. Private sector groups, those were no consumer protection groups, I assure you. And they are contemplating what might happen in the event of major crises. So they knew full well what they were doing. Now, let's look at some of their fine work, these people that are planning what would happen in a collapse. So another part of this is that historically there was something called constructive fraud. Constructive fraud is something that is so fraudulent on its face that you don't have to prove anything. You know, it's just obvious. That's constructive fraud. It's constructively fraudulent. So they had a problem with that because what they were doing was constructively fraudulent. So they had to change, they had to create something called safe harbor, which again sounds nice to have a safe harbor, but what that is safe harbor for the secured creditors to keep the client assets. So this is what these governmental groups and private sector groups were working on in their Armageddon planning. So previously, what would have been considered fraudulent can't be challenged anymore. And there is no requirement to show that any value was even extended into the bankruptcy estate to take the assets out of the estate. So Stephen Lubin is an expert in this area who's written about this shortly after the changes. And now this is important because this is directly connected with derivatives. So it's hard to envision a derivative that now does not get this special treatment. That means that when collateral is extended under a derivatives contract, the party on the other side is assured that they get to keep the collateral. So it covers a wide range of derivative contracts, and essentially all derivatives, present and future, are now protected by safe harbors. But this is the key thing. No regular purchaser of a derivative contract or participant is protected. It is only a protected person, which is only the too big to fail banks. It is only the very biggest banks that are protected by safe harbor. So not just regular commercial participants or a pension fund that would use derivative contracts to hedge. They are not protected. So in the failure of Lehman, and this is very important because this was put in place just in time for the great financial crisis to demonstrate all of this. So J.P. Morgan had taken client assets as a secured creditor while also being the custodian for the client assets. And that historically would have rung every bell as being constructively fraudulent, but it's not any longer. So we'll go into that. So we have the decision of the bankruptcy court in the Southern District of New York, which is Manhattan. The court agrees with J.P. Morgan that the safe harbors apply here and that it must be applied in the interest of market stability. This is the rationale for it, that if you don't protect us, we'll burn the whole house down. So you have to keep us safe or we'll take it all down. So this still is reading from the opinion of the bankruptcy court. This is precisely the sort of arrangement that should be exempt from being upset by claims of constructive fraud. Now, let me back up and say what happened here was there were very large institutional clients that, if you imagine you're in a financial collapse, and they had a lot of treasury securities as their capital. And when Lehman collapsed, it turned out that Lehman had extended all the treasuries of their clients to J.P. Morgan within days before the collapse. So this opinion, this is now 5 years after the collapse of Lehman Brothers. These institutions are still trying to get recovery 5 years later. So it's important to understand, these are the big boys. These were the big sophisticated players that had their collateral taken. Going further in the opinion, so they're saying these were between sophisticated financial players, the precise setting for which the safe harbors are intended. So the only question was whether J.P. Morgan is eligible for this protection. And this is just beautiful. J.P. Morgan is quite obviously a member of the protected class. This is in the opinion of the bankruptcy court. So let's go back and look at this. This is the Fed's statement, and an investor is always vulnerable to an intermediary that does not itself have sufficient interest to cover all the entitlements it has created. If the secured creditor has control, it will have priority. That's exactly what happened there. Lehman had created more entitlements than the entitlements of the investors that had those treasury securities, and the secured creditor that had control had priority. It's as simple as that. So they've given legal certainty there, but they've removed any kind of certainty for the public, but not just someone with their IRA, not just a little person, because these institutional clients, even the biggest players are subject to this. So it's all pension funds, all investment funds also. Now, let me just stop and say, in a way that is a gift to us, because there is no place to hide from this, and it is the one thing that can help us to unite people all the way to the top of the system. It is perhaps the first time in history that we can overcome divide and rule with this, because this is aimed at all people. As I said in the book, that wealthy people think they're special, that they're going to be protected somehow. As I say, you are special. They're saving you for dessert. So people just have to wake up to this, and we can get focused on stopping this. So I talked about that. Yeah, and this was done within days of the failure to secure swap contracts. J.P. Morgan knew that customer assets were being used. So this is J.P. Morgan, the custodian, is taking the client assets, and there's evidence that at the time they were aware of that, well aware of it. And so Lehman had secured control over the client assets. Now this is the key thing. They were not investigated for any criminal wrongdoing. No one was prosecuted, no one went to jail, and literally all the people involved were paid big bonuses for all the stress they were under through the crisis. It was clearly a constructively fraudulent preference transfer benefiting an insider. That's what it would be termed. And this is the way the law used to work. If the collateral was transferred for less than reasonably equivalent value, in this case, it's transferred free of payment. There's nothing being extended on the eve of the bankruptcy. If that is occurring and the entity transferring it was insolvent, which was the case, and these other things would all apply. It's a transfer benefiting an insider. It incurred within 90 days of the bankruptcy. It occurred within days of the bankruptcy. So it rang every bell for being constructively fraudulent. Now, we look at, in this case, the Tennessee UCC, which we've been dealing with lately. So we go to this section. I'll just show you how clear this is in the UCC. So this section deals with priority in security interests with entitlement holders. And the idea is that secured lenders also are entitlement holders. So now this is the key line at the top, except as otherwise provided. It's the exception that you have to look at, but people don't do that. So if you read it without the exception, it says if the intermediary does not have sufficient interest to satisfy both its obligations to entitlement holders and to a creditor of the intermediary, the claims of the entitlement holder, the investor, have priority over claims of the creditor. And this is what the bank lobbyists will read in testimony. They leave out reading the exception. When you go to the exception, a claim of a creditor that has priority over claims of the entitlement holders if the creditor has control. And what I've shown you is they have control all the time. So it's really the exception that is operable, but the bank lobbyists and the legislators that want to, subvert this, they will just read the first part. The second exception is that if the clearing corporation, if these are creditors, if it's a claim of a creditor of a clearing corporation, that has priority, which we've already discussed. But you see it here in the statute, and this is easily reversed just by striking these exceptions. And that's what these bills do. You let it stand that the investors have priority over the secured creditors of the entitlement holders. Stop. Period. And just strike these exceptions. But, of course, the bank lobbyists are going to come down all over this, which they have. That's what we've been dealing with. So then we have, this is another important area, the Bank for International Settlements. This is a document from 2014. This is about collateral management systems. And this is what moves the collateral internationally, cross-border. And they use these terms from the collateral giver to the collateral takers. They actually use those terms. So these are quotes from that document. The desired end goal is a single view of all available securities in real time. And this is globally. This information is a necessary prerequisite for the efficient deployment of available securities to meet collateral obligations. So they have a global view to redeploy all the collateral, and that this system, when they refer to an ICSD, that's an International Central Securities Depository. Now there are some in Europe. DTC in the US was the original model for this, a central securities depository. So they run this optimization process, and that automatically generates instructions for the movement of securities from the givers to the takers. Then they say it's possible that efforts to make this more efficient won't provide enough collateral. It's possible there isn't enough collateral. Market participants may need to exchange ineligible securities as well. So there's not enough collateral. We need even more, and this will all be automated. And they're doing this through the miracle of collateral transformation. Now, this was 10 years ago. Now, what they mean by that is normally the collateral that's extended is cash and high-quality government bonds. But what they're saying is, in a crisis, there won't be enough government bonds. So then we will use collateral transformation. Now, what that will mean is they will say, well, you have all these equities in this pool, And they're not worth as much as the treasuries in a crisis, but you'll take a haircut on that. Maybe we'll swap that for 50% of the value of the equities into treasuries. Now, this is the thing. Those swaps will also be in the derivatives complex. It will also end up in the derivatives complex, but the intention is to use literally all collateral. Then they say in times of market stress, this will have to happen very quickly. We really can't have human involvement, and this will be critical in mitigating systemic stress. So it's all going to be automated. No one's going to make a decision about it. So better visibility, better access to them, rapid deployment of securities to meet margin needs at, now CCPs, that's not the Communist Party. These are the central clearing counterparties. DTC has central clearing counterparties. There are others in Europe. So this has to happen rapidly when there's increased market volatility in order to pledge to central banks in emergency situations. So the collateral will also flow to the Fed, basically, to the central banks, to the central clearing counterparties. And this will have to be automated, standardized, collateral management, market-wide basis, increasingly complex. We can't have humans doing this. Rapid collateral demands. You get the picture they're painting. Now this chart, this is out of that document. And you see here that, let me go back. You see here collateral giver, supply, including equities, derivatives, fixed income. The example of all these, it's global. These are the central securities depositories, New York, London. They're just painting a picture that this is global. Then it is all automated here, and it's all going here. Central clearing counterparties, and these are the collateral takers. So we've had people, when the bank lobbyists came into the States, they just deny that any of this is happening, when it's very clear in these documents that this is very, very well developed at this point. So the global financial crisis, 2008, 2009, was as they say, don't let a good crisis go to waste. There were a lot of things they proved through this. The Lehman case was very important. But the very important thing they did in order to have this go off globally and take everything is central clearing of derivatives. So prior to that, there were counterparties. So people are intimidated by the word derivative. Derivative is just a financial contract. And it's called a derivative because it's not the thing itself. It's written about the behavior of something else. Whether it goes up or down, results in a payment being made or a payment received. So they used the last crisis to say it's just too risky to have a counterparty. So we really need to centrally clear all these things. And it's something that, like all these things, was never examined. The rationale was never made any sense. But it was used to drive this imperative that all derivatives have to be centrally cleared. Now, remember that if the intermediary is a clearing corporation, its creditors have priority over the claims of the entitlement holders all the time. So, central clearing counterparties, they clear all the derivative contracts. If a participant fails, the central clearing counterparty, let's say if Goldman Sachs failed, the central clearing counterparty is handling all those derivatives. But one way or another, in a crisis, all of the exposures for the derivative complex are concentrated in these central clearing counterparties on their balance sheet. So they've done this. Is there a risk that these things could fail, the central clearing counterparties? Well, depository trust, which houses the entire securities complex of the United States and much of the world, and much of the central clearing counterparty activity, the entire capitalization is about $3.5 billion. Now, DTC, these are statements made by executives in depository trusts. The industry has been, for some years now, talking about the imminent possibility of a failure of central clearing counterparties. So DTC itself has said we are opposed to pre-funding defaults. In other words, adding more capital. We're opposed to adding more capital, but what we are doing is pre-funding, setting up a new central clearing counterparty in the event one of ours fails. So rather than adding more capital, we're planning for these to fail and starting up a new one. And they make this statement 3 times in this article. We are planning, pre-funded, start up a new central clearing counterparty. We definitely see the logic to start up a new central clearing counterparty pre-funded. This is the plan. Now, what does that do? Why do they want the central clearing counterparties to fail? Why have they concentrated all the risk there? Because the moment they fail, the biggest banks that are on the other side of these derivative contracts take the assets the moment these things fail. It's absolutely designed, it is absolutely assured. So what they have done is they've taken, when securities were property, the public was absolutely protected from any of this. And what they've done, and what are derivatives? They're contracts. The contracts never would have had any standing in insolvency. So they've done this inversion over all these years to create a situation where the public now has something like a contractual claim. It's very weak. And they've given a super priority claim to just the biggest banks to essentially take all of the financial capital in the world, literally. This is absolutely designed, you can see it all. So it's irrefutable, it's not conjecture. These are their own primary source documents. So derivatives are not real things, but they can be used to take the real things. This is the sleight of hand here. Yeah, I think I've talked about that. Okay, now these are statements made. This is when we were in Tennessee. They sent their big gun to counter us. The head of the Securities Industry Financial Markets Association, he was the managing director and associate general counsel, so he is an attorney. So he knows the reality. These are some of his statements. Regardless of whether ownership is via electronic certificate or on paper, the customer's property rights remain the same. He put that in a letter. He said that in testimony. Holding in street name in no way diminishes a customer's ownership rights. This is testimony. Investors who choose to hold their securities in street name with their brokers are protected by a range of regulations dedicated to ensuring that client assets are appropriately controlled and segregated from the assets of the broker. I mean, I hope you're getting the picture here. These are all just lies. The only thing that he can point to here is the subterfuge is that on the books and records of the broker, they can say, well, we've separated them in our own books and records, but they know full well that all the securities are pooled at the higher level. No securities are actually held at the broker level. So they can make this statement and lie about it. These securities cannot be borrowed, lent, or traded without customers' consent. Absolutely untrue. So this is what we're dealing with. Now, in a way, this again is a gift to us, because what has happened with these bills is it's when people have read this book or seen the documentary, some part of the brain says, well, maybe this isn't true. You know, that's a natural response. But to see it in a bill, that starts saying, well, this seems to be real. Then to see the banking lobby come down in full force and respond, and they cannot address this on the issues. They literally have to lie about it. That says a lot. So that is what is happening. Then we have this letter, the Uniform Law Commission, which promulgates these changes. They did the 94 amendments. They are getting very concerned, so they wrote an extensive letter refuting us on this that came out in March. We had been it was right after we were in Tennessee. And these are some of their statements. Proponents of legislation to amend Article 8 have said that its provisions allow an intermediary to assume ownership of its customers' investment property in the event of the intermediary's insolvency. This is false. That is completely contradicted by what the Fed itself says and what happened in the case of Lehman Brothers. So do you really think that the Uniform Law Commission is not aware of that legal response, that response to the legal certainty group that Lars found for them? So they know full well that this is an untrue statement. This is their next one. Under Article 8, an investor who owns securities through an intermediary has a property interest. They keep asserting this is a property interest. It is nothing like a property interest, even though they assert this. And that they are not subject to claims of the intermediary's creditors. That is, the investors will not lose their assets even if the intermediary becomes insolvent. It's just flatly contradicted by what has already happened. But this is what we're dealing with. So let's say, in a way, this is illuminating because they're exposing themselves. You only have to see that someone is a liar once to know that they're lying. You know, how many times do you have to have it demonstrated? Intermediaries are required by law to hold their customers' investments directly or indirectly through a clearinghouse. In other words, the collateral has been transported up, and are not permitted to pledge their customers' investments as collateral for the firm's borrowing. Any person who violates this law is subject not only to civil damages, but also to severe criminal penalties. Now think about what happened with Lehman. No investigation whatsoever, and they did exactly this. They were using the collateral, the securities of their biggest clients. They did exactly this. So this statement it sounds reasonable. You know, lawmakers read this and they think, well, they're experts. You know, it must be okay. But they're just flat out lies. Finally, although the secured creditor has priority, if the secured creditor is acting in collusion with the brokerage firm to defraud customers, this could be set aside in court, and there could be recovery, which we again saw in the case of Lehman. They could not prevail in bankruptcy court. The bankruptcy court found on behalf of J.P. Morgan. So this is also an untrue statement, that it could be pursued in court and you could prevail there. So this is what we're dealing with right now. This is a 13-page letter from the Uniform Law Commission. It's basically all untrue, everything in it. So now this is another thing that puts the lie to this. They will say that, well, this is the modern indirect holding system, and it just has to be this way. We can't have legal certainty for people for the investors, but we have to provide legal certainty for the creditors or the system will collapse. That's their rationale, that once you've dematerialized, once things are held electronically, it couldn't be otherwise than what we have here in the US. Sweden demonstrated that that was absolutely false, because when Sweden was pressured, the G30, this process began decades ago to force the G30 countries to dematerialize. And the Swedes always want to do it the fastest, the bestest, and get the gold star and the pat on the head for doing it. So they did it right away. But they would never have imagined that it was about stealing the customer's assets. So in Sweden, they implemented it so they had specific identification electronically for every security to the investor. And that is why I moved to Sweden 14 years ago during the financial crisis, because I realized this, and I had to find the one place in the world that hadn't done it. And so the important thing, though, here is that you can have an electronic system to assure that people are protected, because it's been done. And what did they do to Sweden? Sweden complied. They implemented this with specific identification, and customer assets could not be used without a written agreement, exactly what you would want to see. But what happened? Back up. The Legal Certainty Group identified Sweden as a problem, as being problematic, because legal certainty could not be provided. So there was a process of many years to force Sweden to knuckle under and subvert their own system, both Sweden and Finland. And I'm sorry to say that has been done. So they were just getting around to tidying up everywhere, making sure there would be no refuge from this. And I have to say, they've done it. But again, in terms of facing up to something awful and accepting it and seeing what good can come out of it, the good is that it is comprehensive, because now there is no place to hide, and we just have to face up to it. And it is a gift to us, because it is so apparent that this was deliberate. We now know that these people are not benevolent, they are not benign, they are malevolent. Of course, we have a view into that through COVID as well, but in the case of the financial system, it's absolutely true. I think it is really possible for people to focus based on this. They're coming at us with so many things. It's full spectrum assault. So it's going to be very difficult to fight all these different things that are coming at us individually. I think the value of this is that, as I say, it punches the hole so that the information starts going in. When people are overwhelmed, it's like an oilcloth. The information is just running off. We're all subject to that. But once your hole gets punched with something, you start seeing things. So it can do it for us, it can do it for friends and neighbors, it can do it for people all the way to the top of the system. Now the key thing is, all of these threats against us, whether it's disease X or nanoparticles or all these things, they are all being funded by this unlimited money power. So as I would say, the one ring that binds them all is the money power. The only way to stop all of these threats against us is to end their money power. And this helps irrefutably for people to see that that's where the focus needs to be to stop all of this. So there will always be sociopaths. There will always be insane death cults. The problem is giving them control of unlimited funding. So it's a simple thing. Getting there may seem overwhelming. How can that be stopped? Well, this is a beginning because we have an actual mechanism to begin changing this, to begin confronting it, really. I think in Europe, I have to say it's not going to happen anytime soon. I don't think a revolution is going to happen in Sweden. The people, so the EU member states, like as this was subverted in local law in all 50 states, in Europe they had to do it in local law in each nation state, as they did in Sweden. The problem is that you may have observed that the EU is completely unaccountable. There is no ability to control the EU level, and they've set up this mechanism where all member states have to comply with EU mandates, and there's absolutely no questioning about it. And I don't see that changing anytime soon. I think the problem is we're going to. This is escalating. We know we're in this full spectrum hybrid war, and this is escalating. We now have over 1 million people that have been killed in Ukraine. This is, it's already developing into, those are fatalities scaling with what happened in World War I, and this is going to spread throughout Europe. They're going to do that unless it's stopped somehow. So I really believe the hope for humanity, literally, is to stop this at the state level in the U.S. Now, how could that happen? This gives people something that they can act on that makes the battle lines quite real with the banking power. So what happened in Tennessee is the House subcommittee passed this bill 5-1. They then accelerated the hearing in the Senate to the next day. I was there. Don and Betty Grandy were there. We'll talk about who they are. They'll be in the last session tomorrow. So the Senate passed this unanimously the next day. They moved the hearing up so Don and I could both be there for that. They didn't have to do that. So as Betty pointed out, the Republican Senate Majority Leader voted with us. And the previous day, the chairman of the Black Caucus, Democrat, voted with us. So as Betty said, this was now of national significance because, like nothing else, it is clearly nonpartisan. So it is really happening that this can overcome divide and rule. So that is the most important thing, to give us something that we can act on that will overcome the divide and rule. Now, ultimately, the only way they stopped it, this was going through. It was going to the floor of the Senate. There was one more House hearing, and Don and I stayed into the next week because we just knew how important it was. And we were meeting with all of the people that were going to be on that committee. And we had very positive meetings. And on the second day, something changed that morning. And you could see in the people they were actually frightened. It was like that. And what we discovered was that basically the banking lobbyists had gone to the Treasurer of the state and threatened that if this happened, they would withdraw financial services from the state. Now, again, this is a horrible thing, but it is a gift to us because it just makes it so clear how mendacious these people are, and it exposes it. And I had an interview recently where this person in Tennessee was doing, covering this, and at least people there would see it. And he was asking me about that, and I said, well, I guess the people he said, well, what's going to happen? I said, well, the people in Tennessee will have to decide if they like being intimidated. That's really what it will come down to. And then to realize that is an empty threat. The people are being intimidated. That's what's going to happen. It's an empty threat. And I suggested that there is something called RICO. And if they are openly threatening withdrawing financial services from the state, someone has to get in their face and say, look, you are going to be prosecuted just for threatening this. So we really can do this. So there's a session, the closing session, Don and Betty, Julie Auck, who brought the bill in South Dakota. This is historic. South Dakota is the first venue in the world to do anything about this. That is historic. And then we followed yes, thank you, Julie. Please stick it out and come to the last session. We will talk about how actionable this is right now. I mean, if we can get half the states in the country to do this, then things start changing in the country. Thank you. Oh, just 2 quotes. This is not a meeting, it's a mustering. That was Eddie Hobbs in Cork, Ireland, the guy with the St. Augustine quote. And the second is our mutual friend Mads Paulsvig, who stopped the pandemic legislation in Denmark, stopped childhood vaccination, ended the lockdowns in Denmark, and he once said to me, wars are not won without courage. Thank you.
David, thank you.
Thank you.